Many people play a role in the community planning process. In fact, anyone with an interest in your community is free to participate. This video will cover some of the main participants of the planning process, as well as cover 3 types of planning processes that lead to local planning decisions. These are legislative, quasi-judicial, and administrative planning processes. The distinction between these 3 is important because different procedural rules can apply depending on whether or not you're setting land use policy or making decisions about specific development permits. Legislative decisions involve making rules or laws, and some examples include comprehensive or sub-area planning, zoning, and other development regulations. Legislative actions affect the entire jurisdiction or a large number of participants. You might know this type of process as other names, such as the long-range planning process or advanced planning. The Growth Management Act establishes that citizen involvement and public participation is the foundation of the legislative process. Quasi-judicial actions apply to a small geographic area or a small number of people. In quasi-judicial actions, the hearing body, such as the Planning Commission or a hearing examiner, acts as a judge, making a decision or a recommendation about a specific permit proposal. Examples of quasi-judicial actions include rezones or subdivisions. Quasi-judicial actions must comply with the appearance of fairness doctrine to avoid bias and make sure that the process is fair and appears fair. Please watch our video on this particular process for more information. Administrative actions are those that authorize staff to approve or deny a specific permit application. Examples of administrative decisions are building permits or lot line adjustments. For these types of decisions, there is established criteria in the code that will form the basis for whether or not the permit can be denied or approved. State law sets strict timelines and decision processes for administrative decisions. All local governments must have predictable and consistent procedures for making project-related decisions. So who is involved in these types of decisions and how? Elected officials are the legislative body of a city or county. They provide leadership and vision to guide your community. These officials are elected by the public to make final decisions about plans, policies, regulations, and budgets. Budget decisions determine how local taxes will be used in any given year to perform city services such as police and build public infrastructure such as roads. Before making their decisions, elected officials often must consider recommendations made by a planning commission or other advisory boards. Only elected officials have the authority to make the final decisions about comprehensive plans or the development regulations that implement them. Authorized by state law, planning commissioners are citizen volunteers appointed by the elected body to represent the broad interests of the community. Planning commissioners serve as a sounding board for new ideas. They promote the community interest in planning and provide leadership in public participation programs. Planning commissioners perform detailed analysis of policy and regulatory options. Some planning commissions only focus on legislative issues. Other times, planning commissions may be involved in the quasi-judicial process. Staff or city consultants provide technical knowledge and expertise to support the land use planning process. These professionals may research and present information in oral or written staff reports, handle required public notice of meetings and actions, and maintain a record detailing the process and reasons for the final decisions. They draft plans and ordinances for public review, provide recommendations, and process administrative permit applications and enforce local codes. Most local governments hire professional hearing examiners to hold public hearings and make decisions about quasi-judicial permits or to hear appeals of administrative decisions. A hearing examiner is a professionally trained individual, frequently a lawyer, who hears and decides cases based on set criteria. Each local government may decide their hearing examiner's scope of authority. For example, which types of permits will the examiner hold an open record public hearing on, and whether or not the hearing examiner will have final decision authority or be making a recommendation to an elected body. Some jurisdictions don't have a hearing examiner. In this case, a planning commissioner or another body will perform these duties. You might wonder why a local government would allow a hearing examiner to hear and decide cases rather than an elected body. There are many reasons for this, but the key is that a hearing examiner who hears permit cases frees up the time of elected officials so that they can focus more on making policy and regulations. A hearing examiner may also reduce a jurisdiction's land use liability because these individuals are trained to make legally defensible decisions. The elected body may also appoint other advisory boards, such as an arts commission, parks board, or recognized neighborhood association. These groups can provide a broad and expert community perspective. Other units of government, such as tribes, utility districts, state and federal governments, are also actively involved in the planning process. These agencies may propose a project that affects your community, such as a state highway, review and comment on development proposals, or provide grant funding, services, or other activities that may affect development in your community. A final group is the general public. This includes residents, public interest groups, local businesses, developers, even the media. The public is any individual or group who has a stake in your community. Continual outreach to these groups is essential. Their collective expertise and experience will help your community make wise and time-tested decisions.